Good afternoon. My name is Tim O'Rourke. It's great to be back, as always, at Westminster Canterbury. As I've said before, this is my favorite class. I can see a couple of you in the Penthouse Lounge, and we'll have an opportunity to exchange views later on in this session, although I welcome your interruptions as I go along, and I know many of the rest of you are viewing online, and I welcome your questions via my email, polysciprof@cox.net. It's at the bottom of the screen. This is the fourth in a four-part series of presentations on amending the Constitution, why it's both too hard and too easy, and how this fact will influence the outcome of the 2020 presidential election. The first session dealt with the amendment conundrum, and the amendment conundrum goes something like this. The formal process for amending the Constitution has fallen into disuse because it's regarded, rightly or wrongly, as too difficult, and instead the Supreme Court interpretation of the Constitution has become the preferred method of constitutional change, although it's not the only vehicle for changing the Constitution. It's easier to change a seat on the Supreme Court than to add an amendment. And I note that this evening, the Senate will vote on the confirmation of Amy Coney Barrett for the vacancy created by the untimely death of Ruth Bader Ginsburg. But in any case, this fact that the court has become so influential in modifying the Constitution inflames the politics of filling vacancies on the court, and it also leads, I would suggest, to fundamental dislocations in the constitutional structure. And these dislocations, I think, both reduce and enlarge the powers of the President and the Congress, and at the same time, they diminish the role that the framers expected we, the people, to play in the process of constitutional development and change. As I mentioned, this is the fourth, the grand finale in the presentation series. Lecture 1 dealt with the amendment conundrum, which I've just described, and it emphasized that states have a very different kind of constitutional experience than the national government. State constitutions are not only frequently amended, but the state constitutions are often frequently changed. Virginia, for example, has had 6 constitutions, and that suggests that perhaps there might be a happy medium between a constitution that's almost impossible to change and a constitution that might be too easy to change, as some state constitutions are, and that perhaps we could have a more open and fluid and accessible amendment process. The second lecture in the series looked at equal rights based on sex, and as all of you know, in 1972, Congress proposed a constitutional amendment that guaranteed equality of rights on account of sex, but that amendment failed of ratification. And as we found out, much of what the Equal Rights Amendment would have brought about has been achieved in other ways, primarily through Supreme Court interpretation. Last week we looked at electoral college reform, and comprehensive reform of the system has evaded the Congress and the people at large, but there have been more than 800 amendments proposed to change the fundamentals of the Electoral College since 1804, when there was a relatively minor change accomplished through the 12th Amendment. As a follow-up to that, I mentioned that there is this effort underway to go around the constitutional amendment process and change the Electoral College. And this go-around or workaround is soliciting the involvement of various state legislatures. And the way this would work is that if the number of state legislatures sign on to what's called the National Popular Vote Initiative, and that number of states controls 270 electoral votes, those states would agree that they would assign their electoral votes to the candidate who wins a national popular vote, regardless of whether that particular candidate won the vote in the state. And in that regard, I mentioned the case of Colorado, which has signed up for this initiative, but Colorado has something called a referendum, whereby voters can secure a significant number of petitions that puts the legislature's action on the ballot before all the voters. And so Colorado voters will consider whether to essentially endorse or overturn the decision of the Colorado legislature. At this point, counting Colorado, states with a total of 196 votes, electoral votes, have signed on to the initiative. They would need to get to 270 for this initiative to take effect, assuming that it's constitutional. But in that spirit, I note that this weekend's Wall Street Journal carried an editorial urging Colorado voters to overturn or vote down Colorado's participation in the National Popular Vote Initiative. So I hold up here, gambling with Colorado's electors. Today, we come to the question of statehood for the District of Columbia. And this is the question of whether voters in the District of Columbia who already can vote for presidential electors will be accorded the right to vote for members of the House and the Senate. And as you'll see, giving the District of Columbia statehood would be one way in which this might be accomplished. For me, this is something of a revisit to past presentations. In 1991, I gave a series of lectures as part of an Alexandria series called Carving Out the District of Columbia, and I made 3 presentations out of 5 in this series. And so it's like deja vu all over again, as Yogi Berra said. And so I've revisited some of the questions that were part of that lecture series in 1991. Now, I do want to emphasize that there's a lot of fresh material in what I present today, and I had an opportunity a few years later to do some field research. And here I am at the National Stadium with my brother and grandson and my good friend Thomas Jefferson, who had a role in the creation of the District of Columbia, and I'll have something to say about that. And you might notice that I'm wearing a Pirates jersey. I'm a diehard Pirates fan, and it's not just any Pittsburgh Pirate jersey, it's the jersey of the revered and late Roberto Clemente, number 21. And that could figure in this saga, but in the interest of time, I won't talk about Puerto Rico, but statehood for Puerto Rico is being actively explored by Congress. The citizens of Puerto Rico on November 3rd do not get to vote in the national presidential election, but they will be voting on a referendum that poses the question of whether Puerto Rico should pursue statehood. But back to Washington. Here's a cartoon that actually appeared in 1920, disfranchised Washington. And that really is the core issue that drives the presentation today, because when the District of Columbia was taken over by Congress in 1801, the residents then in the district who had voted before 1801 lost the right to vote for U.S. House of Representatives. They couldn't vote for the Senate. I'll come back to that, because senators then were elected by the states. But they could vote for state legislators in Washington and Maryland. And if they lost the power to vote for president. And so in 1920, the voters of Washington were disfranchised. And as you can see from the cartoon, they called it tyranny in 1776. And in 1920, it's taxation without representation. And that argument, in somewhat modified form, is being made this very day. Now, to understand the creation of the District of Columbia, we have to go back in time a bit, and the story begins in the City of Brotherly Love in 1783. The Continental Congress was then meeting in Philadelphia, and a large group of disgruntled Revolutionary War veterans, I've seen numbers 300 or 400, protested the meeting of Congress and kind of threatened violence against the members of Congress. And the Congress was alarmed both by the protesters and by the seeming unwillingness of Philadelphia or Pennsylvania to provide some measure of credible protection to the Congress. And as a result of that, the Congress retired to Princeton, New Jersey. And over the course of the 1780s, Congress considered the question of developing a different and more permanent site for its meetings, and it looked, among other places, at Kingston, New York, and Annapolis, Maryland, Trenton, New Jersey. Even Williamsburg, Virginia was kind of in play at one point. And there was also some discussion about a Potomac River location. And this was a subject that had not been resolved by the time the Philadelphia Constitutional Convention met in 1787. And Elbridge Gerry captured the spirit of the discussions at Philadelphia when he said he conceived it to be the general sense of America that neither the seat of a state government nor any large commercial city should be the seat of the general government. So if you follow that, the notion here is the delegates were not ready to decide where the capital should be, but there was some sense that it shouldn't be in a commercial city like New York or Philadelphia. And there was also some sense that it shouldn't be in the same city as a state capital, that it needed to be independent and free from the influence of a locality or a state government. And that reflects the continuing influence of that odd event in 1783 in Philadelphia. And so, as with several critical issues that faced the framers at Philadelphia, this issue was not resolved specifically, but only on general terms. And so we have in Article 1, Section 8 of the Constitution this language: the Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by cession of particular states and the acceptance of Congress, become the seat of government of the United States. And so, without designating the site, the framers decided that they would create a new seat of government 10 miles square. It's important to understand it's 10 miles on each side, so that the framers contemplated that the size of this federal district would be 100 square miles. The drama now moves from Philadelphia to New York, where the new government in 1789 began. And so George Washington was inaugurated in front of Federal Hall on Wall Street in New York City, and this is now a national memorial, and there's Federal Hall with George Washington's statuary in front. And in the first Congress, and so this is the period 1789 to 1791, the Congress dealt with the question of where to put the capital, and there was a lot of back and forth reflecting the various interests across the original states about where the capital should go. And ultimately, the location of the capital emerged from a conversation among Thomas Jefferson and James Madison and Alexander Hamilton. Madison was a leader of the Federalist Party then. Of course, he changed parties later on in the first House of Representatives. Hamilton was Secretary of Treasury. Madison was interested in finding a southern location for the capital. Hamilton was interested in finding support for what is called assumption. And what Hamilton wanted to do as a way to solidify support for the National Union was to have this new national government assume the debts that the states had incurred during the course of the Revolutionary War. To make a long story short, Jefferson had Madison and Hamilton to dinner, and essentially what happened is that Hamilton thought that he could bring some Massachusetts votes in Congress to support a southern location for the capital, and Madison thought that he could get some southern support for Assumption, which was otherwise disagreeable to most of the South, and thus the Great Compromise of 1790 was effectuated. So we got Assumption, and we got agreement on a southern location, a Potomac location for the capital city. And in the meantime, and this was part of this grand compromise, the capital would move from New York City temporarily to Philadelphia, where Congress would meet until 1801. And so here is a map that shows the bounds of the first of our capital, the District of Columbia, and it's a square. It's 10 miles on each side, and 10 times 10 is 100 square miles. It's carved out of Maryland and Virginia, which ceded the land to the federal government. And so the northern portion above the Potomac River is out of Maryland, the southern portion from Virginia in what was then Alexandria County. And many of the original marking stones, the surveying stones, have been recovered and preserved. I show in a picture one of those stones that is the far west boundary stone in Arlington County, in which Benjamin Banneker participated in the surveying. Banneker was a well-known African-American mathematician and actually lobbied Thomas Jefferson for greater respect for African Americans, and so he has been recognized as an early civil rights pioneer. Well, Washington, D.C., the District of Columbia, no longer is this kind of neat square, and here is the outline of Washington today, because in 1846, Virginia and Alexandria County essentially sought a divorce. As Washington was developing, there was a policy that called for no federal buildings on the south side of the Potomac, and this was interfering with the development of the Virginia portion of the district. And so in 1846, Congress agreed to give back the Virginia portion of the District of Columbia, and so that bottom half of the square now is Arlington County and the city of Alexandria. And Arlington County was originally Alexandria County, but they changed the name so as to distinguish between the county and the city. And so we leap ahead more than 100 years to the proposal and the ratification of the 23rd Amendment. And this is, the 23rd Amendment was proposed in 1960, was adopted, ratified less than a year later, in March of 1961, and it begins to address the problem of disfranchisement that the cartoon at the beginning of this presentation showed. And so, under the 23rd Amendment, the District of Columbia was given the right to appoint 3 presidential electors. Now, the actual language of the amendment is a little more indirect. It says that the District of Columbia will get a number of electors equal to the whole number of senators and representatives in Congress to which the district were entitled if it were a state, but in no event more than the least populous state. And so the least populous state has 3 electoral votes. The District of Columbia has 3 electoral votes. At the time of this amendment, the district, as you can see in the upper right-hand corner, had a population in excess of 800,000 people, and then had a larger population than 13 states. Now, some of you are saying, well, why didn't Congress and the ratifying states fix it all in 1961 by giving the residents of the District of Columbia not only the right to vote for the president, but the right to vote for the U.S. House and the U.S. Senate. And I was able to find some language from the House report that accompanied the constitutional amendment proposal. And the House report says, first of all, that all national elections are stated in terms of the states. So we elect the president according to electoral votes that are determined by state. Members of the House of Representatives are chosen from districts that are carved out within states. And of course, by this time, the 17th Amendment had passed so that people vote directly for their senators, but the election of senators is by states, 2 senators per state. The proposed amendment, the report goes on to say, would change the Constitution only to the minimum extent necessary to give the district appropriate participation in national elections. And the report further says, on the matter of statehood, any attempted divestiture by Congress of its exclusive authority over the district by invocation of its powers to create new states would do violence to the basic constitutional principle adopted by the framers in 1787. Translated, this means the District of Columbia is not a state. It was set up to be an independent seat of government for the federal government, and so district residents are entitled to some voting rights under this rationale, but not to the whole gamut of voting rights that apply to residents of states. However, in 1978, Congress was ready to move further and again resorted to the constitutional amendment procedure in order to give the District of Columbia the right to vote for members of the House of Representatives and to the U.S. Senate. And House Joint Resolution 554 proposed a constitutional amendment that was endorsed by 2/3 of the House and Senate, and I'll read particular sections of this amendment, which was proposed in 1978, sent to the states. Section 1, for purposes of representation in the Congress, election of the President, Vice President, and Article 5 of this Constitution, the district constituting the seat of government of the United States shall be treated as if it were a state. And so this is not statehood for the District of Columbia, but it is simply treatment like a state for purposes of voting for President, House, and Senate. Section 3 of this amendment would repeal the 23rd Amendment, so that, remember, the 23rd Amendment gave district residents the right to vote for presidential electors. And then I mentioned Section 4. It says this article shall be inoperative unless it shall be ratified by the 3/4 of the states within 7 years. Now, one of the reasons that this section is in here is that you might recall that with regard to the Equal Rights Amendment, the 7-year time limit was not put in the text of the Equal Rights Amendment. It was in the preamble to the language of the amendment. And given the controversy over extending the deadline for ratification of the Equal Rights Amendment, various people in Congress said, well, we're not going to have that controversy again. We're going to put the time limit in the amendment. And as fate would have it, 7 years later, only 16 states had ratified this amendment, so it failed. Well, so the residents of the District of Columbia still lack the power or the right to elect members of the House and the Senate. And what are ways that we might give the D.C. residents the right to vote for members of the House and the Senate? Well, constitutional amendment might be one, but that's proved to be remarkably difficult. There has been some talk over literally decades about giving the district back to Maryland, and presumably the federal district would then become something like a fort. question about the constitutionality of this approach. And then there's something called semi-retrocession that would simply allow residents to vote in Maryland without changing the kind of legal framework within which the district operates. There are questions both about the constitutionality of retrocession and semi-retrocession, and also about the willingness to take Washington back. Then there's the possibility of statehood legislation, to which I'll return shortly. And then there has been an argument made that congressional authority over the District of Columbia, because it is essentially total under Article 1, Section 8, that Congress could simply pass a law and give the district residents the right to vote for House and Senate members without the need of a constitutional amendment. And then finally, there's the possibility of litigation, to go to court and to persuade the courts that in fact District of Columbia residents ought to enjoy the right to vote for members of the House and the Senate, as do the residents of every state in the Union. Now, in point of fact, there has been litigation over the last quarter century, 2 different rounds of litigation, to which I'll return shortly, that has sought to secure through the courts the right of district residents to vote for the House and the Senate. But before I get to that litigation, it's useful to look at various provisions in the Constitution that might frame the demand that district residents get the right to vote for House and the Senate. Article 1, Section 2 says that the House of Representatives shall be composed of members chosen every second year by the people of the several states. And the electors in each state shall have the qualifications requisite for the most numerous branch of the state legislature. The Senate is composed of 2 senators from each state. Article 1, Section 4, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof. And so, in reading these passages to you, I think what should stand out is that the electoral structure that is built into the basic fabric of the Constitution is state-based. So we elect again, as I've said earlier, we elect the President, members of the House, and members of the Senate through the states. As I mentioned, there have been 2 rounds of litigation. One took place over a period of 1998 through the year 2000. And in this first round of litigation, which went to the District Court of the District of Columbia, the plaintiffs, who were residents of the District of Columbia, argued that their inability to vote for members of the House and Senate violated, among other rights, their right to equal protection under the 14th Amendment and their rights under Article 1, Section 2 in the 17th Amendment. And just to refresh your memory, Article 1, Section 2 says the people, and the 17th Amendment says the people. And so the residents say, we're people, we should get to vote for the House and the Senate. But the district court in this case essentially emphasized not the people language, but the state language. And the court decided that the principle of one person, one vote applies within states, but not across states or to the Senate. And the court further observed that Congress' exclusive jurisdiction over the district sets the district apart from states. And this litigation actually went to the Supreme Court of the United States, which did not hear oral argument in these cases, but summarily affirmed the rulings of the lower court. And a summary affirmance is not the same as a full-blown testing of the proposition with oral arguments before the court, but it does have some precedental value. Well, in 2018, a different group of plaintiffs went before the District Court for the District of Columbia with a somewhat different argument. And at different points in time, prior to this litigation, a House had passed a resolution saying that exclusive jurisdiction over the District of Columbia gives Congress the authority to grant the franchise to district residents, and the Senate at a different point of time said the same thing. And so the litigants in this case went to court and asked the court essentially to order the Congress to give district residents the right to vote, to tell Congress, well, you've got the power under your authority to exercise exclusive jurisdiction over the District of Columbia. Tell the Congress to grant us the right, and that will solve the problem. The court essentially followed the language and the ruling of the earlier holding 2 decades earlier, and in 2020 said, in essence, voting is through the states, district is not a state, and the court is reluctant to tell Congress what to do in interpreting its own potential authority. Keep in mind that there was no law passed through both houses of Congress signed by the President that would assert the authority of the Congress to grant the right to vote to district residents. And so, this brings us to the option of statehood for the District of Columbia. And the city, or the District of Columbia, the city of Washington, has been aggressive in exploring the option of statehood, and on the right of the screen is a promotional brochure for the District of Columbia calling for making Washington, D.C. the 51st state. And on June 26th of this year, the House of Representatives voted to grant statehood to Washington. The vote was 232 to 180. Every Democrat but one voted yes. Every Republican voted no, and an independent representative also voted no. So it was virtually a strict party line vote. The new state would be called the Douglas Commonwealth, and under the terms of this legislation, the House of Representatives would be expanded from 435 members to 436. So, why statehood for D.C.? And this is a question that comes from the mayor of Washington, the Statehood Commission, and I've tried to present, and this argument follows their argument. And they say the district has greater population than 2 states. It pays more in total federal income tax than 22 states. And although the district gets 25 to 30% of its budget from the federal government, 5 states get a higher percentage. So, some people say the district is just a ward of the federal government. Not so much as some other states. Well, the district residents lack voting representation in the House and the Senate, so it's no taxation without representation. The district also argues, quote, statehood for Washington, D.C. is constitutional. And they go on to say, I'm quoting, the Constitution sets only a maximum size for the federal district. Congress has authority to redefine its borders and shrink its size as it did it in 1846. A reference to that retrocession that gave the Virginia portion of the district back to Virginia. So Congress can make the district smaller, so the argument runs. And Washington also argues creating the new state will require a simple reduction in the size of the federal district to an unpopulated area, which includes the U.S. Capitol, the National Mall, museums, some federal office buildings, the White House, the Supreme Court, and major national monuments. And then the district finally concludes that it can achieve statehood via the Tennessee Plan, followed by Tennessee in 1796, and later by 6 other states. And essentially what this means is that rather than waiting for the federal government to sort of lay out a plan by which the district can achieve statehood. The district is already taking the steps of voting that it wants statehood, of adopting a constitution, and it's simply looking for the federal government to ratify the choice that the district residents have already made. Now, I want to focus on the legal aspects of the statehood question, but it still might be helpful to take a look at the policy elements of this. And this is a chart that shows the population of the states, the District of Columbia, and I've added Puerto Rico because Puerto Rico statehood is kind of in the mix of political discussion. And, you know, the largest state in population is California on the far left with a population of about almost 40 million. The District of Columbia is near the other side of this chart with a population of 705,000. But you can see that at the inset that the District of Columbia is larger in population than two other states. Vermont and Wyoming is not far behind North Dakota and Alaska in total population. And so I just offer this as a point of reference. You might also look at the actual physical size of the district. The district is now, as a result of the retrocession, it's no longer 100 square miles. It's about 68 square miles or 61 square miles if you eliminate water. And this chart shows land area, total area of states. Alaska, 665,000 square miles. This includes land and water. And then the District of Columbia, coming in at about 68 square miles now, is far below not only Alaska, but the other states that are closer. And so if you look again at the inset, you can see that Rhode Island, our tiniest of states in land area, has 1,545 square miles. The District of Columbia, 68. As a point of reference, Virginia Beach is about 4 times larger than the District of Columbia in terms of its total area. And if you look at population just of cities, you see that, of course, New York, with more than 8 million people, is on the far left. It comes in first. The District of Columbia sits at 20 between Denver and Boston. And just as a point of reference, Virginia Beach, with about 450,000 people, comes in 44th. So if we're looking simply at city population, the District of Columbia is large, but only 20th largest city in the nation. So make of that what you will. I think that the most interesting part of this proposal for statehood is how the boundaries of the District of Columbia, Commonwealth of Douglas, would be established. And in the upper left-hand corner is the map of the District of Columbia, its broad contours, and then you see within that map a carve-out, which is called the Federal Enclave. And if you look then at the inset, which is in the bottom right-hand of the screen, this is the so-called Federal Enclave. And it would run essentially from Capitol Hill. It would include the Supreme Court and the Library of Congress, which sit behind the Capitol, down the Mall to the Washington Monument, to the Lincoln Memorial, and on the south it would pick up the Jefferson Memorial, and on the north it would pick up the White House. So it basically picks up a bunch of federal buildings, but not very many people. With regard to statehood, the Constitution in Article 4, Section 3 says new states may be admitted by the Congress into this union. And it's a pretty broad grant of authority, and there are not many restrictions. It says only that no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states. And then I mentioned again that Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. This is in Article 5, provided that no state without its consent shall be deprived of its equal suffrage in the Senate. This might come into play because if the District of Columbia is turned into a state, one could make an argument that Maryland has suffered a reduction in its representation in the Senate without its approval to the new state of the District of Columbia. Well, the Congressional Research Service has looked at this and offered a kind of preliminary evaluation. Kenneth R. Thomas testified before Congress on the statehood proposal, and I pulled out two observations he made. Since the proposed amendment expired, and he's talking about the amendment that would have given the District of Columbia representation as if it were a state, Congress has considered other proposals to give the District of Columbia representation in Congress. In general, these proposals would avoid the more procedurally difficult route of amending the Constitution. The very theme of this presentation, this is the amendment conundrum. And then later in his testimony, Mr. Thomas says, whether Congress can create a state from the District of Columbia raises novel constitutional questions, and there's little case law directly on point. The various arguments that have been raised against such a proposal, invoking the Admissions Clause, the Federal District and Enclaves Clause, and the 23rd Amendment, suggest that legal challenges would likely be brought if H.R. 51 passes. Not a surprising observation because, as Tocqueville pointed out 200 years ago, sooner or later, every question in America seems to end up in the courts. The Trump administration, you will not be surprised to know, has taken a position against D.C. statehood. And 2 days before H.R. 51 passed the House of Representatives, the Trump administration issued its position on D.C. statehood, and I'll read snippets from this, which are crystal clear. The administration strongly opposes the Washington, D.C. Admission Act. The bill is unconstitutional because retrocession of portions of the district into a separate state would violate the 23rd Amendment. If the district were reduced to a small jurisdiction made up of essentially only federal buildings, the 23rd Amendment would give the tiny population living within those borders the same voting power in the Electoral College as the smallest state in the country. So a piece of legislation presumably can't overturn the 23rd Amendment, and that means that that little enclave, the carve-out that runs from Capitol Hill to the Lincoln Memorial, would still have 3 electoral votes, which would be good for the people who live and reside in the White House. Although I guess the president votes in Florida, that's another issue. The scheme proposed in H.R. 51 would likely also require Maryland to agree separately that the portion of the land it originally ceded to the district would now become a separate state. So Maryland gave the land for purpose of the national capital, not for a new state. And H.R. 51 would create an opportunity for a new state of Washington, D.C. to dominate the capital and render those who meet there beholden to its interests rather than the interests of the nation as a whole. As outlined in Federalist 43, the framers feared that the seat of government confined to the jurisdiction of a single state would not be sufficiently independent and might therefore prefer local instead of national interests. And here we're back to kind of the original politics that led the framers to establish this independent federal enclave in the Constitution, back to the city of brotherly love in 1783. The constitutional vision of our framers for our capital was sound. We should not seek to undermine that vision through unconstitutional means like H.R. 51. If H.R. 51 were presented to the president, his advisors would recommend that he veto the bill. And of course, the question emerges, how will the upcoming election turn out? And if Democrats win control of the presidency, the House and the Senate, they might be in a position to accomplish via a law statehood for the district, but it would still be a matter for the courts to ascertain whether this law violated the 23rd Amendment or other provisions of the Constitution. And so we're kind of back to the questions where this began. And a book I very much like, How Democratic is the American Constitution by Robert Dahl, pointed out that the election of the president remains a non-democratic element, and that has fueled the argument for reform of the Electoral College. Equal representation is another area that violates the principle of one person, one vote. And the way that the court has come to take on and decide major issues in American politics is frankly undemocratic. And that would make an argument, in my view, for a more responsive and usable amendment process. The amendment process has become uncommonly difficult, not least because we have not made it work for us. I did mention in the first presentation this pattern of amendment in comparing state constitutions with the federal Constitution. The Virginia Constitution was implemented, not this Constitution number 6, in 1971. And so since that time, the Constitution has been amended 52 times. We've got 2 more amendments on the November ballot. The federal Constitution implemented in 1789, 33 amendments proposed, only 27 adopted. And so the state amendment process has generally been more receptive to change, perhaps too receptive, and perhaps there's a happy medium. Remind you of the ways that the Constitution can be amended: proposal by 2/3 of the House, ratified by 3/4 of the state legislatures or conventions, or 2/3 of the states petition Congress to call a constitutional convention with the same ratification procedures. Interestingly, Larry Sabato, in his book, A More Perfect Constitution, has actually proposed that the convention process, never used, be invoked, and he has an idea for 22 separate amendments to the Constitution, a book that you might enjoy looking at. An earlier book on constitutional reform by an eminent Brookings Institution political scientist also makes the case for formal constitutional amendments. That brings us to the end of the presentation, Amending the Constitution. I welcome your questions on DC statehood or on anything else you've heard the last several weeks. And I see several of you in the penthouse. I'd be pleased to entertain questions or comments.
I don't have anything really about the Constitution per se, but why has it gone all this time and then we still had to vote on equal rights for women? I thought the Constitution gave everybody equal rights.
The short answer is no. A version of the Equal Rights Amendment was first proposed in 1923. The formal Equal Rights Amendment was formally proposed by Congress in 1972 and then not ultimately ratified by the states, but mostly achieved through decisions of the Supreme Court interpreting primarily but not exclusively the Equal Protection Clause of the 14th Amendment, which applies to the states, and the Due Process Clause of the 5th Amendment, which applies to the federal government. To go back in time, in 1872, after the 14th Amendment had been proposed and ratified, it was ratified in 1868, a woman by the name of Virginia Minor attempted to vote in St. Louis, and she argued that the Privileges and Immunities Clause of the 14th Amendment gave her the right to vote. And the Supreme Court in 1876, I believe, ruled that while women were clearly citizens, they were not necessarily entitled to all of the privileges and immunities of citizenship, and in any event, voting was not a privilege and immunity of citizenship, because otherwise we would have needed the 15th Amendment. So you can say that the trajectory of constitutional development favors equality of rights among all people, but obviously we're not there yet. And I think there's an argument to be made for an expansion of suffrage rights in the District of Columbia. I'm a little more hesitant about the notion that the District of Columbia, given its size in land area and population and its relation to the federal government, is entitled to two senators as a state. But it's a good question. Another question.
Why did they say women could not have the right to vote? Simply because we were women?
The answer was that the right to vote was not in the Constitution of 1787, and the 15th Amendment. And so what we've had actually is a succession of amendments to the Constitution, none of which affirmatively give everyone the right to vote, but which say the right to vote cannot be prohibited on account of. So the 15th Amendment, the right to vote cannot be prohibited on account of race. The 20th Amendment, the 19th Amendment, ratified 1920, the right to vote cannot be prohibited on account of sex. And the 26th Amendment, 1971, the right to vote cannot be prohibited on account of age, at least below. So it guarantees the right to vote for those above age 18. Now, point of fact, there are statutory guarantees that prohibit diminution of the right to vote, and there are court rulings that protect the right to vote. Remember Harper versus Virginia Board of Elections. The 24th Amendment banned the poll tax in federal elections. Harper versus Virginia Board of Elections, a Supreme Court ruling, declared Virginia's poll tax for state elections unconstitutional. So what you see over time is this kind of interaction among formal constitutional amendments, congressional action, presidential action, Supreme Court interpretation. My argument or premise in this series is that this intermixture is valuable, but that we have come to depend too much on the court and too little on the process of formal amendment.
Well, it seemed to me like all citizens were given equal rights in the beginning, and then states and other things took some of them away and changed it.
Well, if you look at the Constitution,
It wasn't supposed to be based on sex.
right, if you look at the Constitution, in Article 1, which sets out the rules for the House, it says that the right to vote for the House of Representatives will be extended to those who have the right to vote for the most numerous branch of the state legislature. And so in 1787, the right to vote for the most numerous branch of the state legislature was in every state restricted to white male property holders. Actually, in some instances, African American male property holders, but the point is it was restricted to men, and the states were left by the original Constitution with the right to determine who could vote. And state legislatures were empowered to choose senators, so the people did not have a direct role in choosing senators at all. So it wasn't until the 17th Amendment that people were given the right to vote for senators. So it's not true that we were all equal in the beginning. I would say that it is true that the Declaration of Independence created a kind of aspiration for equality among all people. And I suppose I would say we're getting closer, but we're not there. And that's our obligation as citizens to...
Probably won't ever get there. But nowhere does it say that women cannot vote correctly.
It doesn't say that women cannot vote, but it doesn't say they can. And what it does say is that determining who can vote is left up to the states. And the states denied the right to vote to women until Wyoming in 1889. And so states were granting women the right to vote one by one even before the 19th Amendment was proposed and ratified.
And that was because most of these things were run by men, right?
I don't have a good, I can't refute that argument.
Yeah, it seems to me that with the Trump crowd, they're trying to put women back in pregnancy, what is it, pregnant summer, barefoot in winter again. And really, it's amazing.
But you know, I think part of my problem comes, I grew up with all boys. I'm the only girl, the oldest with 7 brothers.
Well, I can render some advice on law and politics, but I'm not going to try to intercede in family disputes.
Thank you so
Well,
much.
thank you, yes, we've enjoyed it and appreciate it. I'm not sure I understood it all, but
Well, it's
interesting.
I appreciate your great questions and being in the audience, and I appreciate those of you who've watched online. And so have a great week and stay healthy. And I hope we get together again in a not too distant future. Thank you very much.